Hi, Richard Bolger here. Tonight, I thought I would talk to you about one of the most important issues most people face. Certainly, anybody with real estate. They want to know, am I going to lose my house? Can I keep my home? Well, the answer to that question depends upon a number of factors, of course. Uh, One of the most important factors is which type of bankruptcy are we looking at? Remember, for most people, we're looking at Chapter 7 and 13, and that's what I'm going to talk about. Chapter 7 is called a liquidation. So theoretically, one could lose their property in Chapter 7. Now, we analyze people's real estate and other affairs before we file bankruptcy petitions because once you get in a bankruptcy petition, once you file that, once you're in a courtroom, you're not easily able to extricate yourself from that courtroom and that case all the time. So we want to know before we file what is going to happen in that case once it is filed. You're going to want to know that. You're going to want to know what will happen to your house. So we look at your house and we do a quick analysis and we find out, okay, what is the value of the house and how much do you owe against the house? If you owe more than the house is worth, then there's no liquidation value to the house and it won't be sold in Chapter 7 bankruptcy. If you owe less than what the property is worth, but the amount of equity, which is the difference between the value of the property and the amount owed, if that equity can be protected in a bankruptcy case, then you're not going to lose the home in Chapter 7 either, even though there is equity. There's another type of protection, which depends upon how the property is titled in the deed. If the property is owned by a married couple and the debt that they have is not joint debt other than perhaps the mortgage, but they don't have any joint unsecured debt like credit card debt or medical debt or online loans, unsecured loans. If they don't have any of those that are joint and their property is titled together as spouses, then that property is exempt, if you will. It is not a part of your bankruptcy case because there's no joint unsecured debt. So even if there's equity, the married couple can keep that property, or either one of them, if they file a bankruptcy petition. Now, that means, therefore, that in Chapter 7, you will be able to keep your house if there's no equity or if it's owned jointly with a spouse and there's no unsecured debt, or the amount of equity available can be protected by certain protections in the bankruptcy code and state law. Now, there is a problem if you are behind on your mortgage when you file your case. So, even if there's no equity in the property, you're still going to have the problem of the fact that you're behind on your payments, and eventually the lender would be able to foreclose on your property. Usually it'll be months after your Chapter 7 bankruptcy case is over, if at all. And that's because you cannot, what we call, cure the arrearage in Chapter 7, fix the late payments. You can do that in Chapter 13. Now, let me just say there's a lot of nuances to cases, to real estate, to protecting real estate. There are a lot of nuances. And so every case is different. I'm giving you general information, which is hopefully helpful to you as you learn more about bankruptcy. Now, Chapter 13 is not a liquidation. It's a reorganization, and you retain your property. Now, you're going to be able to retain your property in Chapter 13 if you can basically pass a couple of hurdles. One, you have to pay in Chapter 13 over a 3 to 5 year period, usually 5 years for the lower payment, the amount of money that the unsecured creditors would have received in a Chapter 7 had the case been liquidated in Chapter 7. That is called the liquidation test. So, for example, if there was $25,000 of unprotected equity in real estate that would cause a Chapter 7 trustee to move to sell the property, if you file a Chapter 13, you must pay that $25,000 over the next 5 years at 0% interest, and then you can keep your property. So, if there's an arrearage and you have no other way of dealing with that arrearage after the Chapter 7 is over, then there's Chapter 13. Chapter 13 enables you to protect your property. I said there were two hurdles. One was the liquidation test. The other one is feasibility. You have to show that you have the ability to not only make that payment of the arrearage over the next 60 months, but that you can commence making your regular mortgage payments again after your bankruptcy case is filed. So you'll have, if you file a Chapter 13 case and you're protecting equity and you have an arrearage, you're going to have to start resuming your regular mortgage payments after the case is filed, plus you have to make your arrearage payment for the next 5 years as well. We actually call that a Chapter 13 plan payment, and it is comprised of more, oftentimes, than just the arrearage, but we can talk about that another time. Another nice thing about Chapter 13 is if you have a home equity line of credit and it is completely unsecured, for example, your home is worth $100,000 and your first mortgage is $101,000 or more, your line of credit has no actual security to it. It's above and beyond the first trust. So if the first loan is 101, the property is worth 100. Your second trust is completely unsecured and can be stripped off in a Chapter 13 and treated like the unsecured debt that it is. So I've told you briefly ways to protect your home. And let's just say there are scenarios which exist wherein you may desire to let the house be liquidated. And what am I talking about there? I have a client who, elderly married couple, who have some equity in their home, but the amount of debt they have unsecured debt greatly exceeds the amount of equity in the property, and they don't have enough income to make the regular mortgage payment and a Chapter 13 plan payment. So what they're going to do, they've looked at their situation, decided this is in their best interest. They're going to let the trustee liquidate the property. The trustee is going to pay them their protected equity, which is in their case $70,000. And all of their unsecured debt, which is in excess of $150,000, will be discharged. They will therefore be left with their $70,000 of equity in the house and their retirement and Social Security income to live on. That situation is in their best interest. At that point in time, they've eliminated all this unsecured debt, over $150,000 of it, and they are able to live within their means. A word about income taxes and debt. Canceled debt is generally taxable income to the debtor. Now, there was a time back after the collapse of the real estate market after 2007, etc., that Congress passed a law that said debt forgiven as a result of foreclosures was not taxable income. But that code provision expired, I believe, in 2017. So any debt which is remaining after a foreclosure now, which is canceled, is taxable income to the taxpayer. That is a big problem. In bankruptcy, there is no cancellation of debt taxation. Big advantage for a bankruptcy filer. So those are the highlights, I would say, of can I keep my house in bankruptcy? There are a lot of variables, as I said, and this is information which is general in nature, but hopefully helpful to you as you consider whether this might be an option for you and your family. After all, that's what you're really doing, is looking at what is in your best interests, what does the law provide, how can I use it to help improve my situation in life and that of myself and my family. So, have a good evening, and I look forward to recording many more podcasts as we go forward.